this principle in the International Covenant on Civil and Political Rights, Article 17, which guarantees security, and the African Court also recognizes the importance of protecting personal data, integrity, and private life, even if it's from the non-state actors. This honorable court is brought to the attention of a number of legal national frameworks. And in this, we have the Computer and Cyber Crimes Act of 2018, amended in 2025. And this act criminalizes various forms of cyber crimes, including the unauthorized sharing of intimate images. Section 28 of the act, it criminalizes cyber harassment, international causing emotional distress, fear of harm through the electronic images. Honorable bench, it is a breach of this obligation. The law does not require a money to endure weeks of exposure on the ongoing harm before justice begins. Honorable bench, every moment of action was another moment of violation. Honorable bench, do social media platforms, companies have enforceable obligations to remove content? Manipulated content involving the non-consensual creation of images? The answer to this is to the positive. And in the case of Amani, the platform refused to remove the content, immediately saying the content moderators could not verify if the content was synthetic. Honorable bench, the social media platform's delay in removing the images is a failure to protect Amani's personal data and the laws under this act. Honorable bench, in the regional laws, we have the African Charter on Human and People's Rights, and Article 18, Section 3 of it, it obligates the states to protect women's rights. Honorable bench, the African Commission has emphasized that the inaction or undue delay in the investigating and addressing the GBV, it constitutes a breach of due diligence. And the standards are as set in the case of Zimbabwe Human Rights NGO Forum versus Zimbabwe 2006. The Honorable Court and the members of public present is also invited to the African Charter, Article 1 and Article 5, which provides that the state must ensure accountability of violations of human rights, including those facilitated by digital means. Honorable bench, the African Court in Ogiek versus Kenya affirmed that the states are responsible not only for the acts they commit, but also for the act they fail to prevent, punish, or redress. By enforcing the takedowns mechanisms, Kisiwa is legally accountable for the ongoing violations of Amani's rights. Honorable bench, under the Maputo Protocol, Section 4 and 11, it mandates protections from all forms of violence, and it recognizes that harm arises not only from physical, but also from manipulative practices that violate the dignity and autonomy and women, including the private acts and harm that occur in the emerging forms such as the digital harm and the abuse of online. Honorable bench, under the protection against discrimination, which is guaranteed in Article 2, it addresses the gender-based violence because it disproportionately affects women. Women are paying higher prices for being online, Honorable bench. Women in leadership, in activism, in content creation, in politics, and journalism are often targeted to intimidate them into silence. Honorable bench, Amani is a woman and as an activist has faced discrimination and gender-based violence as a result of the deepfake images. The African Charter of Human and People's Rights obligates the states to take measures to eliminate discrimination against women, to protect them from violence. And the state of Kisiwa, Honorable bench, it lacks the adequate implementation laws to address the non-creation of these images and their dissemination. And therefore, the state is failing its duty to protect the rights under the African Charter of Human and People's Rights. Honorable bench, under the African Union Convention on Cybercrimes and Personal Data, also known as the Malabo Convention, under Article 28, Section J, it addresses the cyber crimes, including the child pornography, cyber attacks, and the havoc that Hamani has endured, Honorable Bench, is really unthoughtable. Honorable Bench, we therefore ask the state of Kisiwa, due to its failure to protect her rights, we submit that they have violated the issue set by this case. Honorable Bench, under Article 29, it emphasizes the state's obligation to protect human rights, including the right to equality, dignity, and privacy. The state failed to protect Amani's rights under Article 29, given that the police delayed investigation and response were due to lack of technical capacity. Honorable Bench, under the international laws, we have the obligation to ensure that the effective remedies of human rights violation, your lordship and my lordship, the instrument is clear that the state must act promptly and effectively to protect the victims without excuses, such as the technical capacity, and cannot absolve the state when the harm is ongoing. Honorable Bench, the article emphasizes that integrity, authenticity, and proper chain of custody for the electronic evidence to establish liability. Honorable Bench, the United Nations Special Rapporteur on Violence Against Women of 2021, it highlights the state's responsibility to ensure that the platforms are accountable to prevent the recurrence of the digital abuse. Under the CEDAW, the General Recommendation number 35, it calls on the states to ensure that the technology-facilitated gender-based violence is addressed and that the perpetrators and the platforms facilitating abuse are held accountable. Also, under the United Nations Guidelines on Digital Evidence, Pillar number 1, it requires the government to protect its people from the human rights violations and abuses by the business and other law measures. Under Pillar number 2, it outlines that all companies should avoid infringing on the human rights issues and address negative impacts they are involved in through their due diligence. Honorable Court, the state of Kisiwa ascribes to the Budapest Convention on Cybercrimes of 2001 and the United Convention on the Cybercrimes, also known as the Hanoi Convention of 2025. We have presented the material evidence forms exhibits A1 to A7 for the court to consider in camera or in chamber to purposefully prevent the further publication of the harmful materials in the open court. Honorable Bench, in my final submission, I respectfully pray that this court finds the state of Kisiwa violated Amani's constitutional rights to dignity, equality, privacy, and the security of the person, to issue a mandatory order compelling the state to enforce effective and timely investigations of the TFGBV complaints and ensure platform accountability, and to also affirm that the logistical limitations are not a defense against the human rights violations, as it constitutes with the jurisprudence of the African human rights system. My lady and your lordship, delivering justice in favor of Amani, it's not only just, it is imperative. It affirms that in digital age, rights are real, protections are affordable, are enforceable, and the dignity is inviolable. Much obliged.
Thank you very much, Ms. Nyaga, for those wonderful submissions. Allow me to give Ms. Auma her moment to make her submissions. Thank you.
The Republic of Kisiwa stands before this honorable court to defend its constitutional mandate and sovereign responsibility to maintain public order, administer justice, and to safeguard the rights of all its citizens under its institutional, constitutional, and technical capacities. The applicant alleges that the state has violated her constitutional and regional rights. I seek a rebuttal of this argument and demonstrate that no such breaches are attributable to the state. My lady and my lord, we submit that the harm suffered by the applicant, though regrettable, arose from the independent action of a private individual, outside the direction, control, and endorsement of the government. International and regional laws do not impose strict liabilities on the state for every wrongful act committed by a private individual or person. Rather, it requires to take reasonable and context-appropriate measures once a violation is reported. Honorable Bench, in the matter of admissibility and jurisdiction, the Republic of Kisiwa is a state party to the African Charter and Maputo Protocol, and it has demonstrated in Article 34, Section 6, declaration allowing individual direct access to this court. My lady and my lord, whereas the government admits the jurisdiction of this court in such matters, it, however, argues the application failed to exhaust local remedies. This honorable court requires that all local remedies and domestic legal system must first be exhausted before a case can be heard under Article 56, Section 5 and Article 6, Section 6 of the court's protocol. Honorable courts, the applicant had an opportunity to submit the matter to the East African Court of Justice prior to submission to this honorable court. Honorable Bench, constitutional litigation in the state of Kisiwa requires a petitioner to set out with reasonable precisions the specific rights violated, the exact manner of violation, and the nexus between the allegations, act, and the respondent. This standard is articulated in the Amarita Karanjanjeru versus the Republic, and it requires a clear, coherent, and evidence-based articulation of the state's wrongful conducts. Honorable Bench, we submit that the constitutional petitions must not be used prematurely, interrupt ongoing administrative, investigative, and lawful processes. If it pleases the court, I'll make the submissions. My lady and my lord, the defense will likely focus on the principles of national sovereignty, the state's duty to protect its citizens, and the potential limitation of privacy rights in the pursuit of justice and public order. My lady and my lord, in this defense, we will rely on the following theories, doctrines, principles, and points of law, the details of which we are submitting to the court as a bundle. My lady and my lord, this defense is grounded on 4 foundational theories, and under the attribution theory, this honorable court is invited to adopt a balanced and context-sensitive interpretation of the attribution theory. Human rights are attribution to the state only when the state commits the act, condones it, participates in it, and systematically refuses to act. Private conduct is not a state responsibility unless the state indifference is proven. In the case of Dobla versus Sudan, the court held that the state is not responsible for private misconduct unless it is acquiesced. And my lady and my lords, in the case of Zimbabwe NGO Forum versus Zimbabwe of 2006, the court held that private harm does not automatically trigger state liability. Liability, therefore, requires attributable action, omission, and attribution in cyber cases depend on reliable digital evidence, such as metadata, IP logs, device forensic, and experts analysis. And in chain of custody, stress gaps in petitioner's evidentiary chain. Leo is a private citizen acting independently. The state neither created nor disseminated the defects, as there is no evidence of the state complicity, approval, or intentional inaction. My lady and my lords, under the theory of progressive realization and capacity constraint, The position is articulated in Article 1 of the African Charter on Human and People's Rights and the UN General Recommendation number 3 of the International Convention on Civil and Political Rights on Progressive Realization, which applies by analogy. Honorable Court, resources and technical complaints do not excuse total failure, but they can qualify and justify what is reasonable. The state of Kisiwa is building a digital capacity, hence investigating delays reflects a technical demand, not indifference. My lady and my lord, Kisiwa is not neglecting, but progressively strengthening cybercrime mechanisms. Under the theory of platform governance, the digital forums carry primary responsibility for content moderation, rapid takedown, and clear safety to meet state regulations, but platforms operate autonomously. The applicant shifts full responsibility to the government for the content hosted by the private, multinational, and digital platforms. This theory, my lady and my lords, emphasizes the shared, not sole burden on the state. My lady and my lordship, the state cannot control foreign hosted content or override platforms or override platform algorithm, as the responsibility is shared with digital providers. We also have the theory of harm mitigation framework. And under this theory, it states that the state responsibility often arises after knowledge of harm and is measured by steps taken to mitigate, timely response, and effectiveness of protection tools. My lady and my lord, let it be noted, by the state acted promptly after the notification. My lady and my lord, in the case of Velasquez Rodriguez versus Honduras, which had been adopted by the court, it held that a state is not responsible for every human rights violation. Responsibility attaches only when the state fails to act with due diligence. We also have the theory of proportional state obligation in digital harm cases. My lady and my lords, in the complex, technologically evolving harm, state duties must be interpreted proportionately, balancing individual rights, technical capacities, jurisdictional limits, and operational realities. My lady and my lords, we respectively submit that the defects are new frontier where states worldwide struggle with attribution of forensic tracing. Under the theory of liberalism, it requires for balancing of competing rights rather than absolute priority of one right over another. My lady and my lords, we also have the legal doctrines, and under the doctrine of reasonable state diligence, a state is required to take responsible, context-sensitive, good faith measures to prevent and respond to private harms, not to guarantee perfect, instantaneous protection. My lady and my lords, the applicant is pushing a standard amounting to strict liability. If harm occurs, the state must have failed. However, we argue that the African Charter does not impose perfection, especially in technologically complex context with defects. We also have the doctrine of non-absolute rights. My lady and my lords, not all rights impose absolute, immediate, or unqualified obligations. The applicant treats dignity, privacy, equality as though the state automatically violates them whenever a private actor does. The state protects these rights through laws and remedies. My lady and my lords, we also have the doctrine of due diligence, and it states that state must reasonably under available measures prevent, investigate, and remedy human rights violation. Reasonableness is assessed by resources, technical feasibility, and proportionality. The state of Kisiwa, therefore, exhibited timelines by opening investigation, conducting ongoing communication with platforms, and request for preservations. My lady and my lord, we also have the principles of law. And under the principle of reasonableness, states evaluate action in the light of available resources and technical complexities. 8 weeks is reasonable. 8 weeks is reasonable given cross-border data request and platform operation needs, the novelty of defects analysis. We also have the principles of causation. My lady and my lords, remedy must be causally linked to state omission, demonstrated the social harm is directly attributable to the original publication, not to the state's response delay. My lady and my lords, we also have the constitutional law. The Constitution of Kisiwa, modeled in the transformative Bill of Human Rights structures of the African continent, positions human rights such as dignity, equality, and security of a person at its core. However, it also recognizes the state's obligations are primarily duties of conduct, not absolute guarantees of outcome. We submit that while a money experience is regrettable, it does not, in the law, amount to a constitutional violation attributed to the state, because the Constitution does not impose strict liability on the state for their third-party offenses. And the Constitution also requires that a state of reasonableness, not perfection. And it also recognizes the limits of states in control in private-run digital spaces. My lady and my lords, under Article 28 and 31 of Kisiwa Constitution, they advocate for right to dignity and privacy, respectively. The applicant alleges that Kisiwa failed to protect her right of dignity and privacy against deepfake sexual images created by a private actor. However, we submit that the Constitution of Kisiwa, like the Kenyans in Article 21, Section 1, and the South Africans in the Kumbane versus Minister for Welfare, imposes an horizontal application only where reasonable. Liability for a private individual, malicious digital fabrication cannot automatically be imputed to the state unless the state knew the real and immediate risk and the risk to take measures within its powers. My lady and my lord, Article 27 of the Constitution of Kisiwa articulates the right to equality and non-discrimination. My lady and my lord, the applicant suggests a systemic failure to protect women from TFGBV. However, constitutional equality does not create an absolute shield from all gender-related harms. It requires the state to treat similarly situated individuals equally and enact reasonable policies, which the government of Kisiwa has. The government of Kisiwa has the following laws: the Cyber Safety and Online Integrity Act, the National Digital Harm Response Framework, and gender-sensitive policing protocols. All these, my lady and my lord, demonstrate an institutional commitment, meeting the standards in the case of Law Society of Kenya and versus Attorney General, where the court held that state meets its equality duties where it establishes reasonable protective measures for all individuals causes slip through. Under Article 21, Section 2 of the Constitution of Kisiwa, it states that the state shall take legislative policy and other measures, including setting of standards to achieve a progressive realization of rights guaranteed under Article 43. My lady and my lord, deepfake technology is new, complex, and globally unregulated. And Kisiwa is updating its digital legislations, training cyber officers, and also engaging platforms. My lady and my lordship, this shows a good faith, which is constitutional standard. My lady and my lord, Oversight of digital platforms, often multinational companies with encrypted architectures, belong partly to regulators, legislators, and industrial codes, and not the state. The same Constitution of Kisiwa, Article 21, advocate for the role of the state to take reasonable harm, act when a harm occur. My lady and my lord, Kisiwa acted reasonably, promptly, and proportionately, as it did not fail its mandate under the constitutional obligations. If it pleases the court, I invite my assisting counsel David to proceed with the submissions.
My lady and my lords, under the regional laws, Kisiwa is deeply committed to the African human rights system, operating in good faith under the African Charter on Human and People's Rights, the Maputo Protocol, and the guiding jurisprudence of this honorable court. The court holds that the regional human rights responsibility is grounded in reasonable and not perfection. My lady and my lords, the African Charter on Human and People's Rights, Article 4 of this charter, stipulates about the respect for the integrity of a person. Honorable bench, the applicants argue that digital sexualized deepfakes amounts to a failure to protect body integrity. The duty of due diligence requires reasonable steps, not instantaneous perfection. The African Commission confirmed in Zimbabwe Human Rights NGO Forum versus Zimbabwe 2006 that state is not strictly liable for harms originating from private actors unless there is a clear failure to regulate the act. My lady and my lords, also under Article 5 of the African Charter, stipulates and expound about the right to dignity. Deepfake sexual imaginary is degrading, yes, but the legal question is whether the state violated Article 5. Honorable bench, the state implemented a functioning cybercrime unit, existing legal penalties for image-based abuse, and a gender-sensitive supporting system. My lady and my lords, on the Maputo Protocol, Article 18, Section 3 of this protocol, expounds about protection of women against harmful practices. This provision has increasingly been interpreted as encompassing gender-based online violence. The applicant is right that state must protect women, but protection is a spectrum of duties. Article 18, Section 3 of this Maputo does not require omnipresent surveillance or impossible technology capacity. Rather, as interpreted in the case of Egyptian Initiative for Personal Rights versus Egypt in the African Court of Justice, it requires appropriate measures, including legislation, public structures, accessibility of reporting, and non-discrimination. My lady and my lords, on the international law, Honorable bench, Universal Declaration of Human Rights 1948 provides in Article 12 of the UDHR that no one shall be subjected to arbitrary interference with their privacy, family, home, or even correspondence. On the Convention of Elimination of All Forms of Discrimination Against Women, CEDAW, the state has acted within framework of CEDAW, my lady and my lords. Honorable bench, the state of Kisiwa fully recognizes that under Article 2, 3, and 5 of the CEDAW, state must take all appropriate measures to eliminate discrimination against women, including violence-facilitated digital technologies. However, this obligation, both procedural and substantive, are not absolute. They must be interpreted in light of national capacity, available resources, and also evolving technology realities. My lady and my lords, if it pleases the court, I invite my lead counsel to make the final submissions.
My lady and my lord, human rights litigation does not exist to punish governments for the tragedies they neither caused nor condone, but to ensure that states protect their people with sincerity, diligence, and lawful mechanisms. Kisiwa has done that. The harm manifest is real, but the state is not the architect of such harm. My lady and my lord, if you hold the state accountable or liable for an 8-week delay in digital investigation of every citizen whose burglary or theft case took 2 months to solve, will sue the government for millions. The police force will collapse under the weight of civil litigation, leaving no money to actually fight crimes. We therefore humbly pray before this honorable court to dismiss the application while affirming the state's ongoing commitment to justice for Amani and all survivors of digital gender-based violence. Much obliged.
Thank you. Thank you very much for those submissions. We have received the bundles of your submissions. We will retire at our judgment, and we are very grateful because of those substantive submissions that have been made. Before we give the right directions on the date that we shall deliver our judgment, allow me to ask my colleague if they have a comment, just one comment, before the court arises. On my right, I will allow Celestine. On my left, I'll allow Celestine to comment. Honorable Justice Celestine, thank you.
My comment is to Miss Ouma for the state, isn't it? Did you give us a citation for the Anarita case? Anarita case?
No, I didn't mention it.
It is okay. Ensure they are included in your submissions.
Okay.
Thank you. On my left, I'll allow Justice Kiprono to make a comment.
I think I can see that in the table of the list of authorities. Number 2, the citations are in there. Anarita Njeru versus Republic of Kisiwa,
Yes, my honor.
2021.
It is there in the citations of table of authority.
Thank you. We do confirm that your submissions are well done, together with the authorities that are attached therein. This court will arise. The judgment shall be delivered on the 13th day of January, 2026. Thank you. Thank you so much. The court has ended. We expected you to arise with the court, then you bow. Honorable Chigai, allow us to let you know that the court was not taking so much proceedings because it's a technically, what is it called? Enabled court, and we are doing a recording of proceedings that shall be transcribed, and we shall be able to deliver our judgment virtually on the 13th day of January 2026. So apart from that, I think, allow me, as they clear the table, there is a few things that we just want to make a comment on the purpose of this, this moot court. One of them was that, allow me to let again my colleague just comment on what we were looking at, or what we'll be looking at as we do our judgment. I will start with Mr. Kiprono on my right.
Thank you. We are basically trying to look at the state, the attribution, and the attribution of some of these violations to the state, and the extent to which the constitutional violation of rights on the digital platforms.
Celestine, a comment?
Now, that was a demonstration of the court process. So this is an analysis of what they have presented before the court. Our chair, Honorable Chigai, and everyone else. So on the opening remarks, our advocates, all of them did a good job. The opening remarks were very powerful. They were loud, they were all loud. I believe we could all hear them argue their points, isn't it? So they were very loud, they were very clear, they were very articulate. Now, when the judge says, counsel, let us hear from you, whether for the respondent or for the applicant, it is good to say thank you, Your Honor, or thank you, Your Lady. You receive that part that has been given to you, then you proceed and argue your points. Our applicant